Okay, council, I think we have everyone here. Um, Tony, are you ready?
Yes, Judge.
All right, let's go on the record on DC 245769, Shoutery versus Agricultural Workers Mutual Auto Insurance Company. Council, make your appearances.
Yeah, Robert Grisham for the plaintiffs. Judge?
Reed Loftus for the defendants, Your Honor.
Let's proceed.
Yes, Your Honor. Defendants move to abate this case. This court has previously ordered appraisal for the claims asserted by plaintiffs in this case, and the policy clearly and unambiguously mandates abatement if the claim is an appraisal. And the Texas Supreme Court has held that when the parties identify a particular remedy in their contract, that the terms of the contract should control. We previously had a hearing before this court, and the court asked if there was any cases where the court was required to abate a case. And defendant cited to an Southern District of Texas case and an Eastern District of Texas case, which had the same policy. And both of those courts said that they must mandate or must abate the case because the contract mandates the abatement. And as I said, the Southern District case, it was the exact same policy. And the terms of the policy says, if appraisal is requested, the suit must be abated until appraisal is complete. Suit is not pick and choose certain claims. It's the entire proceeding before the court. The Dallas Court of Appeals held the definition of a suit is any proceeding by a party against another in a court of law. And so the suit, every claim asserted by plaintiffs must be abated while the appraisal process is ongoing. There's nothing ambiguous about the contract or the terms. The court is required to abate this case pursuant to the language of the contract between the parties. And
So one of the arguments made by the defendant is that not all claims are subject to abatement. How do you respond to that?
by the plaintiff, I would respond that the policy mandates the entire suit be abated, not just specific claims. That's been asserted by plaintiffs that certain claims aren't underneath that threshold. However, the policy is clear that it's the entire suit that must be abated, not specific claims asserted by the plaintiffs that avoid abatement somehow. The entire suit has to be abated. Everything arises out of the policy benefits. And judicial economy would be served because even if we take plaintiffs' allegations as true that some of the claims fall outside of the abatement, the scope of this case would be narrowly tailored after the appraisal process is finished.
They cite to a case, Martinez versus National General Insurance Company out of the Northern District of Texas, as well as Gibson Production Company of Kerrville versus Allied Property and Casualty, a number of other ones that they say indicates that if the appraisal doesn't resolve all issues between the parties, including the extra contractual claim, then abatement is not appropriate. How do you respond to those?
Your Honor, I would say the policy in those cases was different than the policy in this case. This case says that the suit must be abated, it's not a discretionary thing. It's a must, and it's a suit. It's the entire proceeding.
Are there any cases that make that distinction?
That make the distinction that all claims, that everything must be abated?
That the policy in your situation, in this case, should be treated differently than the policy in those cases?
I've got the Southern District of Texas case, Your Honor, where they analyze the exact same policy. And it has to do with some extra contractual claims as well. And the court said it must be abated, the entire case.
Did it discuss these other cases?
Not specifically, Your Honor.
Okay. Mr. Grisham, what's your response?
Yes, Your Honor. Yeah, the council is referring to two federal court memorandum opinions. Those do not discuss a significant difference here, which we have the adjusting company and the individual adjuster also as defendants. I'm looking at the policy. It does have the provision of lawsuits against us. You and the terms you and we are bolded, meaning that those are defined terms. That's speaking of the insured and referring to the carrier. And so, I mean, undoubtedly that provision's there. It says suit against us, lawsuits against us. We have claims brought against the other parties that aren't subject to this agreement. In addition, the extra contractual claims that the court mentioned a minute ago, the claims for breach of the duty of good faith and fair dealing, insurance code claims, intentional infliction of emotional distress claims. And we've attached evidence. We've kind of been down this road a couple of times before. This response is a little bit different. We attached evidence from our client. The policy provides a certain limitation for additional living expenses. And our damages, we consider them what's called an independent injury, damages outside the policy. So if the appraisal award affixes a certain dollar figure for the what's called ALE, additional living expenses, that's definitely not going to resolve this case. We have claims for additional damages or independent injury on top of the contractual provision that is being currently appraised. But I looked at all the cases cited by the defendant part of the hearing. I don't see any addressing claims where the insured has brought suit against the adjusting company and the individual adjuster. And whether those would be abated too. I mean, I guess the court could abate the case against the carrier, but we've got these claims against the adjuster and adjusting company. And it doesn't seem
Do any of the cases that are cited by either side discuss a situation where you have additional parties besides just the insurance company that are?
I didn't see any, and I did a search on Westlaw just maybe an hour ago just to see if anything popped up, and I didn't see anything either way.
I didn't see anything, Your Honor. I wasn't necessarily looking at that specific issue.
Do any of the cases decided by you, Mr. Grisham, discuss the particular policy in this case?
They do not. No.
Okay. And do you agree that the policy in this other case that was cited by the insurance company, that that's the exact same policy as what we have here, or do you know?
You know, I don't know. I don't dispute that language or similar language is actually an issue in that other case or the other cases. But I do know they don't address the claims against the adjuster or adjusting company. But it does have language, yeah, the suit against us must be abated. But again, us being the carrier.
All right, at this point, I'm going to deny this. If you find some cases that discuss this distinction, it concerns, I don't want to abate part of the case and not all of the case. There's no efficiency there. And so if you find some cases that indicate that abatement would be appropriate, even with their multiple parties, I'll be glad to reconsider this. But at this point, I'm denying the abatement. Have you got me a proposed order, Mr. Grisham?
I will submit that momentarily, Your Honor.
Okay.
And Your Honor, I know you've already made a major ruling. I just the adjusting company and the agent are agents of the insurance company. So their actions would fall back onto the insurance company. Just
Are they employees or agents?
agents, Your Honor.
But case law is clear. There are independent claims that you can bring against the agent or adjuster. There's a lot of case law on that, dealing with remand of cases removed to federal court. So you could sue, hypothetically, you could just sue the adjuster if you wanted to. I'm not sure that really happens, but I mean, they're independent claims, independent liability under the insurance code in particular.
All right, guys, just so you said you did or did not submit an order, Mr. Grisham?
I did not, but I can upload one momentarily.
So make sure the order says at the beginning that this was heard on November 18th, 2024 on Zoom, and share a copy of it, of the order with your opposing counsel, and then get me the order by tomorrow morning, okay?
Thank you, Your Honor. Will do.
Thank you, guys. You have a great
Thank you.
rest of your day, okay?
You too.
You as well.
You too. Thank you.